I'd like to welcome everybody back to the third part of our discussion on employee reclassification. My name is Pete Gillette. I'd like to thank James Caulfield for joining us again today. James, would you share with us briefly about the direction and control issue and how important a component it is in the motor carrier and independent owner-operator relationship?
Thank you, Pete, for inviting me today. I'd like to first start by saying how important the independent contractor driver is to the trucking industry and the services that they provide. Owner-operators have been and continue to be a very critical part of the evolution of the transportation industry as we know it today. Independent contractors are fueled by the entrepreneurial spirit so prevalent in the American psyche. Some of the largest motor carriers today started out with a single truck and have grown into fleets of thousands of tractors and trailers, not to mention the support infrastructure to operate and maintain such an operation. For instance, motor carriers such as J.B. Hunt Transportation, Swift Transportation, and Warner Enterprises are examples of what an independent contractor can look to become. The motor carrier and independent contractor relationship provides various benefits for both parties, but it's critical to properly establish and maintain the motor carrier and independent contractor relationship. Determining whether a driver is deemed to be an employee or an independent contractor varies depending on various federal, state laws, and regulations. For instance, workers' classification is determined primarily by the right to control test. Control of the manner and means reflects employer-type control, while control of the end result does not. In all worker classification legal tests, the right of control analysis is paramount and generally the primary test. There is a tremendous amount of established law and court decisions pertaining to the determination of the worker status in the transportation industry. You have various courts and regulatory agencies have all concurred that any action taken to satisfy a client's request or preference or to adhere to a government regulation does not demonstrate an exercise of employer control. In 1947, the United States Supreme Court outlined the factors involved in the agency test in a motor carrier's case which sustained the independent contractor status as an owner-operator. It's actually United States versus Silk, 33-1 U.S. 704. In the United States versus Silk, the court stated that the control test focuses on whether the trucking company exercises control over the owner-operator's manner and means of performance as opposed to controlling the end result, which is critical. You know, the standard for determining whether a driver is a covered employee for workers' compensation purposes varies from state to state, and it becomes expensive and challenging to contractually structure a relationship that attempts to reasonably assure broad recognition of both the transportation company's and the owner-operator's desired independent contractor status. I know there's a case now that's getting a lot of recognition. Everyone's got their eyes on it. But if you look at the current litigation pending against Ironbound Express, Inc., the New Jersey-based motor carrier, you find the following legal avenues that are being pursued. One, you got the New Jersey employment law utilizes the right of control test in determining worker status. Classification for the purpose of New Jersey workers' compensation law is primarily based on a control standard. Now, under most New Jersey laws, worker status is determined by what the courts have referred to as the hybrid test, and that includes the right to control analysis and the so-called relative nature of the work test. And the New Jersey Supreme Court has explained that the relative nature of the work test supplements the control test in limited circumstances, and explaining how to apply the test further, explained that the supplemental relative nature of the work test is to be used only when the control test is inconclusive, which sounds rather complex. So when you get to actions regarding the motor carrier and the government and satisfying government obligations, that does not reflect in employer control. As a matter of fact, in 1992, the Interstate Commerce Commission amended the federal leasing and regulations to add a new section found in 49 CFR 376.12, which reads as follows: nothing in the provision of paragraph C1 of this section is intended to affect whether the lessor or driver provided by the lessor is an independent contractor or an employee of an authorized carrier lessee. An independent contractor relationship may exist when a carrier lessee complies with 49 U.S.C. 11107 and attendant administrative regulations. So it's clear that a motor carrier does not establish an employee relationship when he's operating in accordance with a government standard. You can see it too in the case in 1989, the United States Court of Appeals for the District of Columbia explained why the control exercise by a motor carrier because of a government obligation should not be considered in a classification analysis, which means an employer's effort to ensure workers' compliance with government regulations, even those efforts to restrict the manner and means of performance, do not weigh in the favor of employee status. So the employer cannot evade the law in requiring compliance with the law. He's not controlling the driver. In essence, it's actually the law that's controlling the driver. And you see in a 2010 United States District Court decision enumerated various motor carrier actions taken to satisfy a government mandate, including drug testing, background checks, medical examinations, residency confirmation, vehicle maintenance standards, and review of the driver's licensing records, and concluded that the exercise of control over the drivers in compliance with government regulations does not establish an employer-employee relationship. So as you can see, constructing and maintaining the motor carrier's independent contractor relationship is complex and needs to be addressed in light of the fact that the status quo is no longer acceptable.
Okay, James, could you share with our audience who may not have attended the previous two webinars on employee reclassification, tell us the unique creative risk transfer options that are available to help minimize motor carriers' exposures for employee reclassification?
Well, Pete, as you can tell, the various court renderings I referred to regarding the direction and control issues, it's imperative that the motor carrier retain legal counsel that understands the rapidly changing landscape with various pending legislation in both houses pertaining to the misclassification of independent contractors. You know, the motor carrier, along with their legal and insurance advisors, need to view their existing independent contractor relationship agreements and insurance contracts from the perspective of an aerial predator drone hovering about 10,000 feet above the target. You need a well-written owner-operator agreement that can work with some other integrated contractual overlay agreements that need to be added to create the necessary firewalls that will provide additional defensive protections not found in most motor carrier operations. Now, firewalls better protect the motor carrier from federal and state audits and employee misclassification actions. In addition to eliminating all insurance premiums paid by the motor carrier in any type of company-sponsored program, whether it's workers' compensation, back-charged premiums, occupational accident, contingent liability. The coverages really don't matter. Bottom line, if the motor carrier is looking for a way to reduce the company-sponsored insurance premiums by 100%, they need look no further.
Well, thanks again, James, for all your help. And if anybody has any questions, they can contact Kingfish Insurance directly at 888-339-2815.